Planning permission alone does not deliver a development. You also need legal arrangements dealing with infrastructure, roads, drainage, and financial contributions. In this video, we'll break down Section 104, Section 106, Section 278, Section 38, and CIL. Let's look at Section 106 planning obligations. A Section 106 agreement under the Town and Country Planning Act 1990 is used to make a development acceptable in planning terms. It is legally binding agreement between the developer and the local planning authority. It may require affordable housing, financial contributions, open space and community facilities, restrictions on use or occupation. And when looking at the legal tests, a planning obligation must be 1. Necessary to make the development acceptable, 2. Directly related to the development, and 3. Fairly and reasonably related in scale and kind. These tests are strictly applied and limit what authorities can require. Number 2. CIL, Community Infrastructure Levy. CIL is a separate statutory charge, not a negotiated agreement. It is calculated based on floor space and charged by the local authority. Unlike a Section 106, it is non-negotiable. It funds wider infrastructure, not site-specific works, and it is usually payable on commencement of a development. In practice, both CIL and Section 106 can apply to the same scheme, but they serve different roles. Now let's look at Section 104. This looks at sewer adoption and deals with the new drainage infrastructure. The developer designs and constructs the sewer system to the water company standard. Once approved and completed, the sewer is adopted and becomes publicly maintained. There are no statutory tests. Approval depends on technical compliance, inspections, and the bonding arrangements. Section 278, works existing highway. This allows a developer to carry out works on existing public highway. This may include new access points, junction upgrades, traffic signals, pedestrian crossings. And the developer funds the work, while the highway authority controls the designs, approvals, and delivery. Approval is based on highway safety, technical standards, authority requirements, and whether the works are properly connected to the development. Now let's look at Section 38, the new road adoption. This allows a developer to construct new estate roads and wants them adopted. The agreement sets out the construction standards, inspections, and bonding requirements. Once completed to the authority's specification, the road becomes maintainable at public expense. Again, this is governed by technical standards, legal tests. The key difference is Section 106, planning obligations subject to legal tests, CIL, fixed financial levy, Section 104, sewer adoption, Section 278, works to existing roads, and Section 38, adoption of new roads. So why does this all matter? These are not just legal documents, however, they determine whether a development can be built, occupied, funded, and maintained properly. They also affect timing. A project may have planning permission but can still be delayed if these agreements are not in place. So to conclude, these agreements are fundamental to modern development. Understanding how they work is essential not just for lawyers but for anyone involved in property. I make these videos for students, property developers, and anyone who wants to properly understand how real estate works. If you enjoyed this, I'll be grateful if you please like, comment, and subscribe to Legal Development Limited for more. Thank you.